G'day, Kim. How are you?
Hi, I'm good, Andrew.
You done all the hard work?
No.
You got to nail it.
This is my birthday present to Nina.
Nina,
It's
yeah,
her
happy birthday out
today.
there, Nina, who's managed to avoid work today because it's a birthday, but has been working
Oh, no,
hard.
she's been working very
Oh,
hard.
no, don't defend her. It's all right. I'm hoping she hears this. So I can... We are going to talk about fatigue today because we've had a recent reckless endangerment case that's come through in a non-lorry drivey type one where there are particular controls over you having brakes. So we're starting to see fatigue as an emergent issue. And I guess for Kim and I, we really wanted to say fatigue doesn't have to be driving a truck. It can be being a young parent. It can be a whole lot of things. Yeah. If you're on mobile plant and you haven't had a sleep, it's the same as driving for 2 days. So we're going to talk about that a little bit later.
Yep.
What I did want to say, Kim, today or over the last 4 or 5 months, we've both been doing constant training and education psychological hazards. And I guess the thing that struck me most in those presentations is people see psychological hazards like physical hazards, but they are in fact entirely different, because you might see a tripping hazard and never fall over, but the moment a psychological hazard arises, you harm someone. You can see a tripping hazard, you can't see a psychological hazard. And of course, you have no idea the impact that psychological hazard has, because people are not the same. They're different. They have different vulnerabilities. And the other part is that psychological hazards come in clusters. So when I've got plenty of psychological hazards that fall out of my mouth, lack of clarity, lack of justice between people. I could list out of the 14, I'm right up there. But my point is that all of us, through unconscious bias, DNA, and acquired learning, are inclined to have more than one psychological hazard in the way we lead. So what sits behind all of this is a very deep understanding that leaders need to reflect and be self-aware, because it's not like you're stopping one hazard coming out of your mouth. The moment you open your mouth, there's 4 or 5. So I just thought it would be nice just to share some of those observations, probably to kick off a bit more of a discussion around it, but to realise we see psychological hazards in the design stage as often being very small things. Me saying to Kim, can you just get this done on time, please? Without me thinking through, but I just gave her 8 folders of documents to read in 2 hours. She's not going to be able to do it. So we don't actually quite see it as all that serious, but actually it's serious for 2 reasons. One, it harms immediately. Second, it creates aggregational harm. And then, if I break my leg, I can get a cast put on it. I can get it reset. I'll be right in 5 or 6 months' time. By the time I've hurt you every day for 6 months, you will not recover. And workers' comp data shows absolutely, you're away for more than 4 weeks, there's a 50% chance you will never come back to full-time employment. So I just want to identify why psychological hazards are relevant and why we're dealing with them and how serious they are, and don't get lost. And they're also your most expensive premium hit on workers' comp if you're a cynic.
Yeah, true.
Okay. Well, why don't we get onto the case law? Because I thought the retrospective resignation case, really not a very important case. It's a case of a person who said they resigned one date, 3 days before the date at which they advised their employer.
Yeah.
So it was the 21st they advised, and the 18th the day they said that they had resigned. That's pretty important, because if they had resigned on the 18th, they would have been 3 days late in making their application.
Unfair dismissal.
Yep. And the Fair Work Commission said, no, it's the date you advise, not the date you say when you haven't advised. So, in fact, he was within time.
Yeah.
But I guess the importance is resignation. And Kim, Nina and I probably over the last 6 months have given you 20 resignation cases of heat of the moment resignations, just to remind you. But when someone resigns, it is a time to take stock. So the first thing you do is you confirm it in writing back to the person. You are deliberate in saying you're sure this is what you want to do. You might be the person you want to get out most in the world, but without having a conversation that shows it's not heat of the moment, it's a bit late when they come back the next morning and go, I want to come back to work, because they'll be allowed to. So remember, all the evidence you can build up to show it's not heat of the moment means it's not heat of the moment. But it's a formal process. You don't just get a resignation and say thanks. You confirm it immediately in writing. Okay? So why don't we move on to the next case? Again, not the world's most exciting case. You might think today these aren't our most exciting cases.
I'm so disappointed being a Tasmanian in this decision, though, I've got to say, by Metro Tasmania.
Well, look, can I say to you, some things stick out like an extra head, really, don't they?
Oh no, come on.
No, but this is a really dumb case, and you sort of wonder. Well, I actually looked to see who advised them because I was struggling to understand who could be so stupid as to run the case. Because it's a case around personal leave. Person's wife
No,
was
parental leave.
So yeah, parental leave. Yeah, you go. Well, you go, but it's a dumb case.
Okay, a bus driver put in for 8 weeks paid parental leave because his wife had a emergency cesarean.
Yep.
And she couldn't be the primary caregiver. So he was the primary caregiver for the child. Medical certificate confirmed that she wasn't able to care for the child, but Metro Tasmania said, you failed to give us appropriate notice and it wasn't your intention to be the primary carer. So we're going to deny you 8 weeks.
So the reason I put this is me put this case in because I read and just started rolling around the floor and thinking, this is perhaps the dumbest argument I've ever read in my life. Now, this is an enterprise agreement argument. It's not so much a Fair Work argument, okay?
Yeah.
So we're not going to get stuck in what the Fair Work Act says because the entitlement to parental leave, paid parental leave and unpaid parental leave was set out in an enterprise agreement. But who thinks like that? Wife has an emergency cesarean, you wrap your arms around the person because you know they're in for it. They've got a wife who's crook, they've got a child who needs care.
Yeah.
Who would think to deny them leave? Who would think?
No.
So just remember, try and use a bit of a bullshit detector when someone comes up with a cunning argument and go, what would I look like to the rest of the world if I do this? And what they look like to the rest of the world is mean-spirited people.
Yes.
And the truth is, they ran the case, so they are. Really, that's the truth, isn't it? And they lost, and boy, did they lose. Yeah. Look, another interesting case, again, not of any great merit. When you read the case, you go, look, Andrew, why are you doing this? Well, I'll tell you why I'm doing this. It's an enterprise bargaining case. This is what's in an enterprise agreement as to classifications. And the Fair Work Commissioner just looked at it and went, I don't know what any of this means. And the reason they did that is because lay drafting had introduced bits and pieces, and they'd cut and shut bits of things and stuck it together, and no one had thought, does it make sense? Now, I know you don't think that happens in enterprise agreement. It happens in every enterprise agreement I'm in. In the last minute, people agree to clauses and ideas which are untested and dumb. This is a case which created uncertainty for 6 warehouse workers and a business, a very substantial business, which was in here competing against the Duluxes and the other Hames and those sort of people, and they got it wrong. And the Commissioner made it very clear they got it wrong. So please, you don't have to come to me to draft it, but you do have to test a provision to make sure that any 15-year-old could understand it, because that's the test in enterprise agreement. Can a 15-year-old read that and unequivocally say, it means this? If they can't, well, there's your union organiser in trouble.
Can I just be cheeky and do a shout out to Hames Paint, Australian-owned paint manufacturer, unlike Wattle, who have gone through a few different overseas ownerships in recent times. I think she's done that. Anyway,
look, next case, fascinating case. This is an argument of sexual harassment against Comcare.
Yeah.
It was a woman who's obviously put in a workers' comp claim.
In defending it, they lodged a witness statement by a former boyfriend and employee, saying that she had provided photos of herself when she was working as a sex worker.
And I assume that was at the relevant time. Otherwise, who knows? Yeah.
And she claimed that was sexual harassment under the Sex Discrimination Act. And so when the court looked at it, they said, well, yes, it was unwelcome. It would have offended and humiliated her. But because it wasn't of a sexual nature, there was no sexual conduct as such. And there was no sexualised taunts or insults as part of that. It wasn't sexual harassment.
For Kim and I, the world's very simple. We look at the elements of a particular claim, and you go to the elements, you don't go to the noise that sits around it. Going to the noise, this was an attractive argument, because it's an unfair argument in some ways. Yeah. But the reality is you just look at what are the 3 elements of sexual discrimination and go, yes, unwelcome, yes, hurt, humiliate, intimidate, no, sexual in nature. Easy, isn't it, really? When you do it that way, that's what they pay the big money for in lawyers, isn't it? To actually stop listening to the noise and just look at the facts. Now a case that I do think is really important, which is the Yarra Trams case. These are people, we know the people who go and inspect on trams, and on this case, people had spat on them. There'd been violence towards one person, and the HSR, trying to find out the information, tried to identify who they were, because it was a broader problem that sat there, and the HSR was refused that information
by Yarra Trams.
By Yarra Trams. Well, VCAT wasn't of the same view, which VCAT, when they heard the application, said no, they are entitled to do it. They've actually, to do their job, they're allowed to be seized with the correct information to understand if their members are at risk. When you look in every jurisdiction, and we're going to test this in the problem for you, by the way, so we will take this for a bit of a dash.
It's a big case study today.
It didn't seem that big when I did it.
Yeah, it never does.
It's a big case study, though, but I do that because I don't have to read it. The powers of an HSR do have a consultative mechanism that sits there for the more serious things like provisional improvement notices and directions to cease. But the really important part about it is they are entitled to request documents in respect to their members that relate to an issue that could create a health and safety risk. That's it. They're allowed to do a video of it. They're allowed to take photos of it. They're allowed to draw plans of it. They are allowed to accompany the inspector, particularly if they've come in a dispute that's been called, but they are allowed always to accompany an inspector. Don't treat them like the enemy. They're your employees. Like, the thing I don't get about this is there was no upside in doing it.
No.
What Yarra Trams effectively did is industrialise an issue, which was a safety issue. So I don't know anyone at Yarra Trams, and for those people who do know me, I'm very sorry. But this was so stupid, it doesn't bear scrutiny. No. When there is a safety issue that relates to one of your employees that's being agitated by the HSR, for which that person is part of a group, and they're trying to protect them, they're doing their job. To try and frustrate them makes no sense at all, because it's likely they will have information you don't have, and your job is, under your primary duties, to protect your employees. So if you work together, you may find you build trust with your employees and your HSRs, and suddenly you're collaborating around safety rather than using it as an industrial tool. So that's the reason I put it in there, because I just thought, why would you do it? And the VCAT decision, I think, was, well, it was uncontroversial. Again, it's one of those cases where you look at somebody and go, why did you run this? You're always going to get mud rubbed in your face. And now you've empowered the HSR and you've made them more industrialised, and you're always going to lose. So what did you think you were trying to achieve? We will never know what they're trying to achieve. What's next, Kim?
We've got our main topic now.
Oh, I've got a main topic.
There you go.
All right. I've made that a bit longer than normal, haven't I, the main topic? But I guess, I really did want to say, we forget, when we talk about fatigue, we think it's limited to interstate drivers and people like that, and there's a whole lot of different jurisdictions that sit around that, which are being arranged, and we think that's really the only fatigue issue that we've got. Now, the case I think we've got here is a delivery driver, so not subject to that legislation at all, just subject to safety law. And been working 12 hours?
He was 12 hours into his shift, and he drifted into the path of an oncoming truck. And the company have been charged with breaches under section 21 and 23.
And there's a single director, isn't there, as well?
The director's been charged with reckless endangerment.
So,
and on the basis there were inadequate rest breaks, he wasn't trained properly, he wasn't given adequate time out of his truck, and that all led to...
Do you know, it's so easy. I was driving in from Mornington Peninsula after getting up at 5 for work, and I was struggling. I was on the Monash and I was tired. So I took a rest break with a bottle of Coke. That actually worked really well for me, because I understand interstate truck drivers use drugs. So I thought, I'll use the nearest thing I can get that's legal, and it's Coke. And I sat there for 15 minutes and the caffeine roared into my veins and I was wide awake. But I guess my point of telling that story is it affects us all. Now, part of the reason that I'm tired is not just that I got up at 5 o'clock in the morning, but there was some urgent work I had to get out, and I got to sleep and woke up at 1 and thought, I've just got to get this done. Did it, went back to sleep, but I had broken sleep. I don't need a lot of sleep to function, but when I have broken sleep, it does me in. All of us have days like that. All of us who've got young kids have times where we're up half the night with a sick kid or a crying kid or whatever. So a lot of our lives are disrupted. What this case says absolutely, particularly for officers, is where fatigue could be an issue with one of your high risk jobs that you're doing, like mobile plant, for instance,
Mm.
like heavy plant and equipment, like traffic management, like all the really high-risk things. Do you deal with it at all? And the answer is, as I look through our clients' portfolios of policies and procedures, the answer is no. Do I have a method of checking it? No. And yet, what's the obvious method of checking whether someone's tired? It's actually making sure as they clock on or as they come through to work, you have a chat with them. And fatigue is very obvious on someone's face. It's not something which is easy to hide. Makeup doesn't fix it. So to not have a checking mechanism when you have a high-risk activity where you know fatigue is a high risk is likely to attract prosecution, is my point. So it's not, this wasn't international truck driver. This was a delivery driver. It could have been a salesman in the car. It could have been a person on a forklift working in a warehouse. It makes no difference because the principles are the same. So that's sort of why we did it, wasn't it? Really to agitate and say, well, what does it mean? And one of the things you'd think about, we do some fatigue management here because there's times when we have a lot going on and we'll see a young staff member starting to wilt. We send them home, make sure that they're getting on, getting in taxis or getting in trams or getting there safely. We're aware of it as a professional service business, which means if we can be aware of it, I guess is what I'm saying, well, we don't have dangerous plant equipment, we just have me as the major risk in the place, then in more dangerous environments like agriculture, like manufacturing, like roadworks, like delivery drivers, you've got to do something about it, don't you? You've got to ensure that people are having their breaks, and if that's in a factory, you make sure people don't work through the whole shift, which sometimes happens. So that's the reason. And we go and push this a little bit further. So why don't we go on to our case study?
Okay.
It's
Do you want to talk about the other cases?
Oh, is there another case?
There was.
But what's the other case?
A slide for that. Just the yes. A bus had broken down and 2 mechanics had been sent off by the bus company to fix it. And one of them, as he went off the bus, a driver came past, so a different situation. But they'd been affected by prescription medication, Valium, and had driven over the line.
Can I just say there's an added touch to this which shows that it was an issue that they'd agitated and thought about, because the 2 people knew they had to remove the bus from the highway where it was up into a ramp to do it. So the issue of the risk that sat around it was a known risk, okay? And yes, what happened is after they'd fixed it, they got out, and when they got out, they got knocked over by somebody who was on prescription drugs. My point about, this is a really great case because this is true traffic management. We think traffic management is on a site. Traffic management is wherever there is traffic. And having people wandering around on highways where we know people use drugs, where we know people use alcohol, because the police pick them up every day. So remember, for officers, do I know there is a risk that exists? Absolutely, I know there is. So you're on risk, primary duty. 144 in Victoria, 27 elsewhere. You're on risk. As a company, it's a lay down misere, because is there a hazard? Yeah, there's a road with cars on it. Is there a level of risk? Well, there are certain hazards which are incredibly high level of risk. Are they on the road? Yes. What are the controls? I don't have any. I'll let them walk out. And this is another interesting part of this case, is that there was some consideration of policies and procedures, but there was a gap in the policies and procedures. Now, I'm not the greatest fan of policies and procedures all the time. But this is an example of what happens when you have inadequate ones. So you have them, but they're not good enough. Then the prosecution go to the gap and say, aha, look, what happens if you do have them, they are adequate, and you don't follow them? And the prosecution goes, aha, this is what is reasonably practical, and you didn't follow it. And that's why safety law is emerging out into critical risk management, looking at the 4 or 5 things you must do based on a critical risk, so that you don't end up creating this backbone of liability which nobody uses in policies and procedures, but people are always competent doing high risk activity. I just want you to know, when courts look at incidents like this, what they do is they go, was there a hazard that was known to you? Yes. Tick. What was the level of risk? Even without a drunk driver, okay? Somebody who swerves to avoid stone on a road or whatever. High risk, really high risk, highway, people moving quickly. what's the control? Don't let anyone walk on the highway. That's what and remember, these are not safety people. These are judges. These are common law judges mostly who are dealing with stuff who think of negligence. They go, but if you go on the road and high hazard, high risk, the level of control and the hierarchy of control has to be to exclude the possibility of being struck. So you're not allowed on the highway. They're right. But that's how a judge looks at it. It doesn't look, well, if you stand there and you're on a walkie-talkie and say it's safe to go out now, judges are not interested in any of that crap at all. They're just interested in going, hazard, risk, control. Okay, breach of the standard of care, so it's not a safe working environment, gone. Yeah. Good case. Yeah, really good case. You ready for it now?
Yes.
Let's go to the case study. Now, I did do this early this morning, so it's a bit longer than
Nick Kickfisher. George manoeuvred the concrete boom pumping truck next to the scaffold, witches' hats lined the pathway for the ready-mix concrete trucks to reverse and discharge their concrete into the pump's hopper. The entrance of the site traffic was managed by Stop and Go Management Company. The site consisted of many contractors working for the principal contractor, Tall Build, who were contracted to erect a 30-floor residential tower. All the work was focused on the 35-metre deep pit where foundational work was underway. TB's foreman, Toby, noted that one of the ready-mix trucks had broken down and was blocking the path for other ready-mix trucks, which were now 8 deep in the road outside the site. Time was critical given the nature of the drying speed of the concrete for the pump and existing trucks. He asked Kurt, a D9 Caterpillar bulldozer driver.
That's a bloody big bulldozer.
Okay, I
wondered. Huge, the size of the room. Beautiful.
I thought, how did you know these two?
Beautiful piece of machinery.
Okay. He asked Kurt, the Caterpillar bulldozer driver, big beast of a thing, undertaking earthworks for TB, to tow the cement truck out of the queue to the pump so others could gain access whilst the ready-mix driver and diesel mechanic got the broken down truck going. Kurt and George moved the truck away from the queue to the pump, parking it near the edge of the excavation. As they walked out from between the dozer and the truck after decoupling it, they were struck by a mobile crane carrying precast cement piping into the excavation area where the foundations were being embedded. Both of them died. The mobile crane wet hire company was a subcontractor of TB. The subcontractor owned 3 mobile cranes and worked predominantly in road construction. This was the first time they'd worked on a large building site. Their driver, Kate, had signed the SWIMs and been inducted to site. The traffic management system did not include handheld transceivers.
Walkie-talkies.
Right, good. I'm glad you clarified. Thank you. She did not know people were near the parked dozer and cement truck and couldn't have been told. There was no traffic management team dealing with the area where the vehicles were parked, even though it was a narrow section of the downward ramp into the foundations. It was the only access and egress path from the bottom of the pit and carried significant traffic. Kate had been working 16 hours straight. She had a young child at home and had not slept properly for several days. She was visibly tired and yawning. Toby, the foreman, had met all contractor employees at Smoko for a safety toolbox meeting involving risks on site. It was a simple discussion around the SWIMs and critical risks. Toby observed how tired Kate was and even asked her if she was all right, and she said yes, but he did no more. TB site HSR sought and was refused a copy of the traffic management system prepared by TB's safety consultant. After lengthy and difficult meetings with the site foreman and engineer of TB, Angus, the HSR, issued a direction under Section 74 of the OHS Act to cease work and called WorkSafe. He also issued a provisional improvement notice and sought access to the safety plan, consultation notes and traffic management plan under Section 58. He advised he would then accompany the inspector from WorkSafe who had attended to investigate the deaths and took photos, videos of the accident site, drafted plans of the area.
It was early in the morning when I drafted this.
Sorry. Long sentences, my
I know.
And sought profile technical drawings of the affected area. Toby intervened when he saw him taking a video and told him to return to work and stop videoing things. Angus pushed him away and said he was doing his job. Toby advised him that striking a company officer was serious misconduct and he was immediately stood down. He had to attend work the following day to show cause why his employment should not be summarily terminated.
There we go.
And you didn't make me swear. I'm pleased with that. There we go.
Well, not yet.
So, Andrew, was Angus entitled to make the requests, direct a cessation of work and follow the inspector around the site?
So that's the first, and the answer is yes. Easy, isn't it?
Yeah. Did Toby and TB have risks under Part 7, Division 9 of the OHS Act, discrimination and general protections in the actions taken against Angus?
Yeah, both of them reverse onus. So the fact that he pushed him is pretty low level for a construction site. I know that's not a good test, but it's a good start with it. It's so unlikely the termination will be upheld. The discrimination provisions do have a significant penalties of $50,000 for the individual and $250 for the organisation. They're not used a lot, but they are very effective, and when prosecuted, almost invariably successful, which goes back to the Patrick Stevedoring case, and it's a shoe-in for general protections. Like, it's the easiest general protections claim you've ever run. Somebody carrying out their activity is a pure workplace right. So I know this all sounds a little bit odd, but what I'm trying to show you is there's a whole lot of things that happen around safety, which if you just do the right thing, you don't got nothing to worry about. Why would you ever withhold stuff unless it has person's private information or it has confidential information in relation to the business from an HSR? I don't know. Anyway, did Toby and TB have risks around Kate's fatigue, and what should they have done? Absolutely they did. Okay. Once you say what is a critical risk on a building site, you've got traffic management, you've got working at heights, and you have mobile plant. They're your three biggest. Okay, can't miss them. You've identified the person is fatigued. You've actually seen it and you've raised it with the person. The answer after that is you need to make a few more inquiries, and you need to be satisfied and keep a bit of an eye on her afterwards to make sure that her guarantee that she's fine is not. And you see her yawning again while she's driving around. You've got to tell her, no, you've got to stop. Come back after you've had some sleep.
Especially given the activity she was engaging in at the time.
I know. Anyway, so yeah, just finishing that up a little bit. So yes, Toby personally has a liability around that. That's the thing that I want you to remember, because reckless endangerment applies to anybody. Was there a serious risk of injury or harm? Yes. Was he indifferent to it? The mere asking is not enough. Okay? So yes, for him and TB, of course, have an attribution reckless endangerment because Toby did it there on notice. What happens? Let's just test a bit. What happens if Toby didn't notice it? Well, the answer is it's probably a primary duty breach at that stage. So if often with safety, it's like this. If you do nothing, sometimes you're safer. But unless it could have been noticed, then there's a failure to have a system in place, which is quite a serious breach. But WorkSafe would struggle to prosecute. But here there is real knowledge. It's known and there's apprehension around it. So problems. What were the safety risks and repercussions for TB and its officers given the 2 deaths on site? Forget about how tired Kate was, because even if Kate was alert and fine, the lack of traffic management control was horrendous. And on that basis, this is one which borders on the edge of industrial manslaughter, okay? Because the breach was so fundamental. You have large vehicles going up and down a single access point. Cars are parked there, people are walking across, and there is no traffic management. You're actually guarding the front door. That's such a primary duty breach of such significance of criminal in nature. I think they'd be lucky to get out of industrial manslaughter. So the case is about a lot of things, but one of them is to show how WorkSafe is gradually levering up the nature of prosecution and what are the things are their focus. Mobile plant, traffic management, working from heights, absolute, definitely going to be charged with something serious, and we've seen it recently with the fatigue. So there you go. That's it for this week. We've done all right. We're both fatigued, so we've got through that all right. And thank you very much for listening. Here's cheers. Thumbs up.